From the opinion pages of the Wall Street Journal, this is Potomac Watch.
The Supreme Court issues a 6-3 decision upholding a U.S. House map in South Carolina that had been blocked as an unlawful racial gerrymander, with an opinion by Justice Samuel Alito that seems to raise the bar for such claims in the future. Plus, the Environmental Protection Agency awards a $50 million grant to Climate Justice Alliance. But who is this group and why is it getting your tax money? Welcome, I'm Kyle Peterson with the Wall Street Journal. We are joined today by my colleague, columnist Alicia Finley. Opinion season is here now at the Supreme Court as the justices release the opinions on the big cases they've been hearing over the past term while they're preparing to head off to summer break. And last Thursday, the opinion was a case called Alexander versus South Carolina Conference of NAACP. This involves a U.S. House map that was drawn after the 2020 census, and specifically the 1st District, which runs along the coast toward Charleston from the Georgia state line. This was historically a Republican district, but in 2018 it was won by a Democrat before it was narrowly retaken in 2020 by Republican Congresswoman Nancy Mace. So after the 2020 census, there were population shifts that required redrawing of some of these districts' lines, and the state lawmakers decided one of the things they would do was make the 1st District a little bit more Republican. So they drew the lines to raise the Republican vote share from 53% to 54%. This was challenged and blocked by a district court, which was then appealed up to the U.S. Supreme Court. Let's listen to a piece of the argument last October in this case. This is Justice Samuel Alito and Lee Adden, the senior counsel for the NAACP Legal Defense and Education Fund.
Is there any reason why one or more of them could not have drawn up an alternative map that met the legislature's stated partisan goal but had a different effect on the racial composition?
Because once again, we think that we proffered evidence that was as good as, if not comparable to, an alternative map.
But you admit they could have done that. It wouldn't have been a big burden for them to do that.
Well,
and they didn't do it.
That the legislative record reflects that the partisan justifications did not become clear until midway through trial. For most of the legislative session, most of discovery in the case, the enacted map was defended as being compliant with traditional redistricting principles.
I mean, this whole case is about disentangling race and politics, right? That's what the whole case is about.
Alicia, part of the context here is that the Supreme Court has previously held in a 2019 case called Rucho v. Common Cause that partisan gerrymandering is non-justiciable, meaning that state lawmakers can go after a census and say, we want to make this district slightly more Republican, and the federal courts are not able to hear and adjudicate those cases. Maybe that's the place to start as we talk about disentangling that from racial gerrymandering. Can you give us a sense of that argument, why the court said in Rucho that partisan gerrymandering was non-justiciable?
So when we talk about non-justiciable, it means that basically courts don't have authority to hear a case. And in that case, it was a 5-4 decision. And the issue of whether partisan gerrymandering is justiciable had been an issue that had come before the courts for several decades. And Anthony Kennedy, or the former justice, had kind of prevented the Supreme Court, I'd say, from actually saying what they did in Rucho, which is that partisan gerrymanders are not the province of the federal courts to decide. It left it open that maybe state courts, and we have seen in recent years that a number of state courts have struck down maps under the state constitutions. But basically what the Chief Justice said in the opinion is, I'll quote from it, excessive partisanship in districting leads to results that reasonably seem unjust, but the fact that such gerrymandering is incompatible with democratic principles, quote unquote, does not mean that the solution lies within the federal judiciary. They wanted essentially to get out of the political thicket of map making. How do you decide map is too democratic or too Republican? Some of these quote unquote experts that the plaintiffs often proffer in these cases put out various models for voting gap, which really are essential proxies for equal representation or proportional representation. And by that, I mean that if 60% 60% of registered voters in a state are Republican. Therefore, about 60% of congressional seats have to be Republican. One of the problems with that is that Republicans are often more scattered in rural and suburban districts, while Democratic tend to be packed in urban areas. So the idea of equal or proportional representation, the Supreme Court had already dismissed that. And now in Rucho, it just said, we're going to get out of this area entirely. We're not going to be trying to micromanage map making because it just politicizes the courts. And I think they're right. And as a result of Rucho, what you've seen is that the plaintiff groups like the NLWACP, as well as Eric Holder's redistricting group, have now filed all sorts of challenges against state legislature maps, mainly drawn by Republicans, claiming that they are racial gerrymanders or are either impermissible under the Constitution's Equal Protection Clause or Section 2 of the Voting Rights Act.
That's a piece of what Justice Samuel Alito says in this majority opinion. He says that the standard for finding racial gerrymandering needs to include some kind of direct evidence where a lawmaker says they are drawing maps based on race, or some kind of stronger circumstantial evidence than the plaintiffs in this South Carolina case brought. Otherwise, it would allow plaintiffs to circumvent that Rucho case if they get a map that they don't like because they think it is unfavorable to them in partisan terms. Here's what Justice Alito says. Under the district court's reasoning, a litigant could repackage a partisan gerrymandering claim as a racial gerrymandering claim by exploiting the tight link between race and political preference. Instead of claiming that a state impermissibly set a target of Republican-Democratic breakdown, a plaintiff could simply reverse engineer the partisan data into racial data. And he's focusing on the fact that in many of these states, in many of these districts, voting partisan preferences are polarized highly by race. And so that makes it difficult in many of these cases to tease out, was South Carolina trying to shore up the first district and doing that by moving lines to include more Republican voters and fewer Democratic voters? Or was it trying to shore up the first district by moving lines to include more white voters and fewer African-American voters? And what he's saying is that district courts need some sort of direct evidence before they're going to make a finding that lawmakers were racially gerrymandering. And he cites also a nonpartisan expert who helped draw this map, a career employee, saying that he relied 100% on partisan data and not racial data. But Alicia, part of the trick here is that sometimes states are also required to look at racial data when they're redistricting under the Voting Rights Act, because they're required to create or protect minority-majority districts. And so the effect is sometimes that the drawers of these maps are in a situation where they have a lose-lose. They're required to look at race a little bit in order to protect minority-majority districts, but if they rely on race too much when they're drawing these lines, then they end up having a constitutional problem.
I think that's right. And I think that was an issue going back to the Supreme Court decision last year, the Alabama decision involving the Voting Rights Act, Allen v. Milligan, which concerned whether it required 2 or 1 majority-minority districts. And all of this actually goes all the way back to this Thornton v. Gingell's opinion in 1986 that the Chief Justice has actually been very critical of, and it sets certain parameters and prescriptions for drawing or when you must have a majority-minority district. And when I mean majority-minority district, it means like majority of Blacks or majority Hispanics make up a district. Some places like California, increasingly, minorities will soon become the majority, which just goes to show how outdated the Gingell's opinion is. And actually the idea under the Voting Rights Act that people and groups vote in a cohesive manner and therefore are entitled to a majority-minority district. Justice Clarence Thomas had a concurring opinion in which he cited an example from Washington State in which a district court concluded that Hispanic voters in a majority Hispanic district lacked an opportunity to elect the candidate of their choice, and even though the district elected a Hispanic Republican, so the court purported to correct the lack of Hispanic opportunity by imposing a remedial map that made the district substantially more Democratic, but slightly less Hispanic. This just goes to show how the Gingrich Supreme Court precedent has really gone off the rails, and itself allows judges to essentially impose their own views of how maps should look on state legislatures.
Hang tight. We'll be right back in a moment. Welcome back. Alicia brings up this concurrence by Justice Thomas, and his argument is that the Supreme Court should extend the logic of Rucho and say that racial gerrymandering is also non-justiciable. And he says that courts don't have the kinds of tools that they need to answer these questions. And I have some sympathy for his argument here because redistricting involves many trade-offs. I don't envy the people in these state legislatures who are asked to draw up these maps because they know they have to adjust the district lines so that each of these congressional districts contains roughly the same population, the same number of people. Courts want compact districts, districts that don't sprawl in strange sorts of shapes. You see some of these shapes in the media, certainly, and also in these court cases when districts get challenged. On the other hand, sometimes there are communities of interest is the term that the map makers use. And sometimes communities of interest don't have normal shapes because they follow a state's coastline or they follow a river or some sort of geographic feature that is not the kind of perfect square you would imagine if you're thinking about what the most compact district would be. And then there are also splits of counties and so forth that map makers try to minimize or avoid. But of course, if you are trying to unify one county in order to get back to equal populations in these districts, that might mean that you have to split a different county somewhere else. And so the argument that Justice Thomas makes is these are fundamentally political decisions because they involve trade-offs, they involve bargaining, and they are not the kinds of things that justices or judges can have a bright line rule in order to adjudicate. Is this over the line? Is this not over the line? Is this too much or is this not enough? And Alicia, part of what I think is important for listeners to understand about this Justice Alito majority opinion is how it might change the litigation environment. So this is the bottom line for Justice Alito and the court's 6 conservatives, the majority in this case. He says, if either politics or race could explain a district's contours, the plaintiff has not cleared its bar. And so it seems to me that that will raise the standard for lower courts in adjudicating these kinds of things. And these kinds of cases are not rare. Here's a news report from WLRN, Florida Public Media. This was last Thursday. New racial gerrymandering lawsuit takes aim at South Florida's powerful congressional districts. This is a lawsuit filed by the ACLU of Florida, alleging that 4 U.S. congressional districts in South Florida, Districts 19, 26, 27, and 28 were all racially gerrymandered, as well as 7 districts in the Florida House of Representatives. And Alicia, I would suspect that the people that were filing that lawsuit and the people who are considering other lawsuits like this in other states may have to go back to the drawing board as they take on board what 6 justices of the U.S. Supreme Court have now ruled.
Maybe. I think that's optimistic. In some cases, the decision by the Supreme Court in the South Carolina case, it was somewhat narrow and limited to the facts of this particular case. And it provides also guidance to these groups that if they want their cases to be heard, not tossed out, that this is what you need to do. You at least need to provide an alternative map. You need to actually show direct or at least very strong circumstantial evidence that race was the main motivating factor, not partisanship. Now, I'd also point out the irony of these cases is that, in fact, liberal groups are challenging these maps because they do believe that they are partisan gerrymanders and they are trying to get them re-gerrymandered by courts to favor Democrats. They are actually using race as a proxy for partisanship. It's not the Republican legislatures who are doing this and basically using kind of politics as a proxy for race. It's actually the other way around with the Democrats and the liberal groups are suing. Now, I think Justice Clarence Thomas's opinion makes a very strong point, and I'm not sure if he's convinced his other colleagues on the court of this, But I think they are probably getting tired of having to hear these cases, whether coming up on appeal or sometimes you get an emergency docket when a local or district court strikes down a map shortly before an election. And there have been a number of these cases. Then the Supreme Court has to decide whether to weigh in and stay the district court decision or let it stand. And aren't they getting tired of being in this political thicket? And how do they extricate themselves from this? And again, Justice Thomas makes a good and strong point. Judges don't want to be deciding whether there's too much race or not enough any more than they want to be deciding whether maps are too Republican or too Democrat.